Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide. Let me finish.
Before we get into this, make sure you hit that like button, subscribe to the channel, and turn on notifications, because what you are about to see is a perfect example of why our courts matter and why radical activists in black robes are a threat to the rule of law. This hearing tells you everything you need to know about what the left is trying to do to America from the bench.
Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Let
me finish. That's more than any other district judge in the entire Seventh Circuit. In fact, you rank 7th highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the 7th the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision making. And as I explained, I came on, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from...
I thought you said you'd never looked at these statistics.
I haven't, these particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch, and oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
of course parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the 7th Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, When you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify, there, I was local counsel. Our Supreme...
Yeah, but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the
When you
brief.
sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay. So they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy.
Okay.
I would never
Tell me
sign...
what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10
You
years...
were giving the court advice about, say, ban assault weapons. What is... You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief. You signed it, and you don't know what. And you said abolish assault weapons, and you don't know what you wanted them to abolish.
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief. You signed it.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago I could have answered your question,
And
but
Judge,
sitting here today,
you think
Senator,
you
your
deserve to
time
be
has
promoted
expired.
with this record?
Senator, I stand by my record. I stand by my record.
Senator Butler.
Thank you, Mr. Chairman. Congratulations to you and your...
All right, folks, today we are reacting to a Senate hearing that should have every freedom-loving American paying attention. This isn't just another boring confirmation hearing. This is a straight-up clash between the rule of law and ideological activism. What you're hearing in this clip is a senator grilling Mr. Park, a judicial nominee, over his record as a government lawyer in North Carolina. And let me tell you, this isn't about personality. This is about whether someone can be trusted to follow the law or whether they believe their own politics matter more than the Constitution. The senator starts by asking a very simple question. Would you lie to get confirmed? And from there, it goes downhill fast. Why? Because when you actually look at Mr. Park's record, a pattern starts to emerge. A pattern that conservatives have been warning about for years. The senator calls him what he is, an activist. And that word matters. An activist lawyer, especially one working for the state, has one job. Represent the client. Not your feelings, not your ideology, not what you think is morally superior, your client. In this case, the client was the people of North Carolina. Let's talk about the voter ID case because this is the heart of the issue. The people of North Carolina, through their elected legislature, passed a voter ID law. Whether you like voter ID or not, that law was passed legally by representatives chosen by the voters. The NAACP sued, which is their right. But once that lawsuit was filed, the Attorney General's office had one responsibility: defend the law. According to the senator, and backed up by the record, Mr. Park's office did the bare minimum, if that. No expert witnesses. No affidavits. No aggressive defense. No injunction or stay. Just a weak, half-hearted effort that looks an awful lot like intentional surrender. And when lawmakers saw this happening, they tried to intervene themselves because they believed their own lawyers weren't defending them. That alone should raise massive red flags. Now, here's the part that should make your blood boil. The Fourth Circuit Court of Appeals ruled in favor of the state. In other words, Mr. Park's client won. And yet, the senator accuses him of trying to undo that victory by seeking further review. Think about that. A lawyer trying to overturn a win for his own client. That's not advocacy. That's sabotage. Mr. Park tries to explain it away by saying he wasn't involved at the trial level, that he was only an appellate lawyer, that there were parallel appeals, and that he did defend the law in briefs. And sure, the words sound nice. But conservatives have learned the hard way that words don't matter nearly as much as outcomes. And the outcomes here are clear. Time and again, when conservative laws were on the line, the defense was weak, reluctant, or openly aligned with the left's policy goals. The senator brings up school funding cases, where the Attorney General's office argued in favor of forcing the legislature to spend more money, directly undermining the elected representatives of the people. Again, not the job of a government lawyer. Your job is to defend the law as written, not campaign from the courtroom. Then there's abortion litigation where Mr. Park claims he had no role. Maybe, but the pattern remains the same. Conservative laws get little to no defense, while progressive outcomes are quietly supported. And this is where the senator makes his most important point. This is not just dangerous for a lawyer. This is extremely dangerous for a federal judge. A judge is not supposed to decide what they think is right. A judge is supposed to apply the law. Period. When someone believes they are smarter, more virtuous, or more enlightened than the Constitution, you don't get justice. You get tyranny in a robe. The senator flat out says he doesn't think Mr. Park is mature enough to be a federal judge, and honestly, that may be the nicest way to put it. Because if you believe your personal ideology gives you the right to bend the law, then you have no business anywhere near the federal judiciary. This hearing perfectly exposes the left's long game. They know they can't always win at the ballot box, so they try to win in the courts. They put forward nominees who sound reasonable, who hide behind legal jargon, but whose records show consistent hostility to conservative laws and constitutional limits. That's why hearings like this matter. That's why scrutiny matters. And that's why patriots need to stay engaged, informed, and loud. Because once these judges are confirmed, they're there for life. And the damage they can do lasts for generations.